Hi, everyone. Welcome to our second PowerPoint for Unit 2. In this PowerPoint, I'm going to focus a little bit more on the concept of federalism, which remember is the idea that we have both a state government and a federal government operating at the same time, and that we are always working on a balance between the two, and that the Constitution gave us the idea that we have both state and federal government. So what we need to talk about with federalism is how both state government and federal government can exist at the same time, and who has the power to do what. Because as you can see, even in our modern times, we still struggle with the powers of the federal government and the powers of the state government. This is nothing new. It's something the founding fathers grappled with, and we still see it today in our century. So before we start talking a little bit about which government has the power to do what, I want to introduce you to a word that we see often and discuss often in the law, and it's something called jurisdiction. We sometimes hear the phrase, the court doesn't have jurisdiction, or the government has jurisdiction. And what jurisdiction really boils down to is it means the power of a government body to act. What government body has the power to do something? Not every body of government can govern the same. A really easy way of thinking about it would be, let's say here in Massachusetts. We know that in Massachusetts, we have certain driving laws. You have to be a certain age to take driver's ed classes, and then you have to be a certain age in order to take a test to get your learner's permit. And then at some point, you can move on and obtain your full driver's license. But can Massachusetts pass laws for the citizens of California to tell them what their driving laws should be? No, we wouldn't expect that. In fact, we know that every state can make its own driving laws. So the idea that one state like Massachusetts doesn't have the authority or the power to regulate, to pass laws about the driving age in Massachusetts is what we're talking about with jurisdiction. Another way of saying this would be to say that Massachusetts doesn't have jurisdiction over the citizens of California as to driving age, nor does California have jurisdiction over the citizens of the United States for our driving age. It cuts both ways. What about states and federal and even international governments? Another example would be, does Massachusetts, or any state for that matter, have the authority to enter into a trade agreement with different countries around the world? No, we don't have a situation where a state on its own can enter into a trade agreement with China, with Japan, with Germany, with another nation. That's the role of the federal government. So again, another way of saying this would be that the state of Massachusetts doesn't have jurisdiction to enter into treaties or trade agreements with other countries. That belongs to the federal government. So we'll talk about jurisdiction throughout this semester, and if you're a paralegal student and taking other law classes, you will certainly talk about jurisdiction in other contexts as well. So let's talk about jurisdiction and federalism in the Constitution. As we've already mentioned, the Constitution set up a framework where we have a federal, a national government, and the different state governments. And one of the articles, and I'm sure you already read the part, hopefully you did, about the different articles in the Constitution. But one of the important aspects of the Constitution was for the Constitution to turn to all the states and all the citizens of this new country and say, so here's your federal government. But we don't want the federal government to become too big. Remember, we're trying to break away from England, and we don't want the federal government to have all the power. We want states to have powers too, which seems a little ironic today because we think of the government as being a very large body, but leave that aside for a second. But for our purposes now, the first goal of the federal government was to be more limited in its power. So Article 1, Section 8 of the federal government of the U.S. Constitution sets up what we call the enumerated express powers, the powers that were given to just the federal government and the federal government only. And these, I want you to take a look at the full list. You can pause the video and hop over to it now. But a couple of examples would be the power to establish a post office. That was given only to the federal government. Think about how our mail system works now. We don't have a different mail system, different stamp system for each state. It's only a federal government power. Another similar example would be coining money. Could you imagine if you wanted to go up to New Hampshire or Maine or Vermont for the weekend and you had to exchange currency the way you do if you go to Canada or Mexico or another country? We don't have that. We established one coin system. So these are just some examples of the express powers that the Constitution said, hey, you, federal government, these powers are yours. Those we call the express powers. So take a look at the full enumerated powers. We also have set up in the Constitution both exclusive and concurrent jurisdiction. So I want you to take a minute and think about these terms. Exclusive jurisdiction is jurisdiction that we give only to the federal government. So this is what we were just talking about with these enumerated express powers, like declaring war, entering into treaties, establishing a post office, right? These are exclusive only to the federal government. But there's a lot of other areas where both the federal and the state government regulate us. A really good example of this is taxes. Yes, we are all familiar with the fact that both the state government and the federal government can tax us. And so we call those powers concurrent powers, meaning they can happen at the same time. Both the federal government and the state government can establish the power to tax. Can you think of any other examples where both the state and the federal government have the powers? I'll let you think about it for a few minutes. But another good example would be regulations over certain crimes, for example, concurrent jurisdiction. So what can the states do? If the federal government was granted these express enumerated powers and the federal and the state governments have the concurrent powers, where does that leave the states? So the 10th Amendment to the Constitution, and if you'd like, pause the video here and go take a look at it. The 10th Amendment is special because the 10th Amendment said every power that is not expressly granted to the federal government belongs to the states. And this is really important because what it basically preserves for the state is what we call the state's police powers. And that doesn't just mean a police force, but it means the power to regulate what happens to its people and where and how we operate our own livelihoods in our states. So some really good examples of state power is establishing road systems, establishing schools, how to draw property lines. These are all really critical powers that belong only to the states, and these are reserved to the states in the 10th Amendment. A couple of other features we have to talk about when we talk about the balance of the federal and state. So which one's more important? The state government or the federal government? Well, it turns out that the federal government, even though the federal government was established as a limited form of government, not to be so big, and there's your express powers, another important article of the Constitution is what we call the Supremacy Clause. And this clause says, federal law, you are supreme. So what does that mean in practicality? It means that even though we have 50 states that are all establishing their own laws and taking care of their own citizens, where there are conflicts, the federal law is supreme. So I'll give you a couple examples. One of them is the example of blue soda pop. It's clearly a made-up example, but it could be true. So imagine that the state of Massachusetts passes a law that says it is illegal to sell blue soda pop anywhere in the state. Okay, so a state passes a law, blue soda pop is illegal. But imagine if the federal government had already passed a law or thereafter passes a law at the federal national government that says all soda pop shall be treated equally. All soda pop must be sold in all states. Well, now we have what's called a conflict, right? We have a national law that says you shall not discriminate on the basis of blue soda pop. All color soda pop can be sold. But you have a state that says blue soda pop is outlawed. I know it's kind of a hokey example, but it really makes sense to think about the Supremacy Clause. So which one governs? Well, imagine if I am a store owner in Massachusetts and I go to sell my blue soda pop because I'm complying with the federal law that says I can do that. And the authorities in Massachusetts arrest me and they say, you can't sell blue soda pop, that's a state law. Well, I can challenge that state law in court And I can say, not so fast, Massachusetts. The federal government is telling me that federal law is supreme, and the Massachusetts law doesn't get to stand because of the conflict. So this is a really interesting clause, and we can actually see it in play today with both marijuana laws and immigration laws. For example, immigration is an area that's charged just for the federal government. Only the federal government can make laws pertaining to immigration. And when states try to make their own immigration laws, as Arizona did a number of years ago, those laws are struck down because the federal law is supreme. Another place we see this, although the challenges have been limited, is the proliferation of marijuana use laws. As more and more states permit legalization of marijuana, not just for medical reasons, but also for recreational reasons. What about federal law? Well, there is still a federal law that declares marijuana usage illegal. So there is a conflict there, although no court so far has struck down a state law permitting marijuana usage. A little bit of an interesting tidbit there. The last clause I want to talk about, we talk about the balance of power. And federalism. I do want to draw your attention to the Commerce Clause, and I did link some articles for you on the Commerce Clause too in your unit here. The Commerce Clause is a really important clause in the Constitution and has a long, lengthy history. And this is a clause that said, okay, remember, we have all 50 states, well, at the time only 13, but we have all these states and we have a national government. The Commerce Clause is a grant of power to the federal government to regulate commerce, and of course, you have to interpret what commerce means, between the foreign nations and among the several states. So what this means is the Constitution granted to the federal government the power to regulate commerce between the states. And I think the idea behind this was that states need to be able to do business with each other, and citizens across state lines need to do business. But for a long time, the Commerce Clause was not used very much. And then starting at the time of the New Deal legislation coming out of the Great Depression, the Commerce Clause was used as justification to really grow the federal government. The Commerce Clause was even used as justification for the 1964 Civil Rights Act that allowed Congress to come in and govern discrimination across state lines. So over the most of the 20th century, the Commerce Clause allowed the federal government's power to become more expansive than it had ever been before. To this day, this is a justification for a larger federal government. However, we've seen a little bit of a rollback of Commerce Clause power in the last 20 to 30 years. Back in 1990, Congress passed a gun control law on the grounds that Congress could regulate gun control across state lines, and that was partially struck down as being too far a reach of the federal government. We also saw more recently that portions of the Affordable Care Act, also known as Obamacare, were struck down as being too expansive under the Commerce Clause. So just another important clause when we think about the balance of power between the state and the federal government. And we see that even today, this idea of federalism, which powers belong to the federal government and which powers belong to the state, are still highly and heavily debated. That's the end of our second PowerPoint. See you in Unit 3 when we dive deeper into how bills become laws in the legislative branch and the judicial branch.